Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 99. And first of all, I'd like to start with a point of clarification. Although the podcast does qualify for CPD points, no Pokemon will be available for capture during this podcast. The three cases which we do have for you on this episode cover a decision on a whistleblowing complaint, a further Islamic headscarf case in the European Court, and an update on a case that we mentioned in episode 95 on restricted reporting orders. As usual, don't forget you can access us via iTunes. The podcast's available on the iTunes. It's on the Mayor Brown Internet, YouTube, Twitter feed, of course, where we post out the links. And finally, if you stick with us to the end of this, a couple of items in connection with episode 100, including in particular a competition to while away the long and slow summer days. Stay tuned to the end of the podcast for more about that. So, first case, Royal Mail Group Limited, and I think it's Juti, J-H-U-T-I. And I think mispronouncing the claimant's name would be to pile injury on insult, given the litany of wrongs that apparently were done to her, according to the findings of the Employment Tribunal, by her employer. I'm just going to call her the claimant throughout, rather than mispronounce her name each and every time. The claimant started to work for Royal Mail in September 2013 and was dismissed a little over a year later, allegedly, very allegedly, for poor performance. What happened, according to the findings of the Employment Tribunal, was that she went to a meeting early on in her employment with another Royal Mail employee. During that meeting, the other employee, who had apparently not been entirely honest in her dealings with the claimant, offered some pricing incentives to the customer, which the claimant believed were entirely inappropriate and contrary to regulatory requirements. Very shortly after this, the claimant reported her concerns to a manager, Mr. Widmer. According to the findings of the tribunal, Mr. Widmer pushed back strongly when these concerns were raised, and as a result of it, she ended up writing what the tribunal described as a deferential apology email to him, effectively retracting the concerns that had been raised. Mr. Widmer, therefore, after started to performance manage her in a very aggressive way, and which the tribunal found was simply setting her up to fail. The claimant raised concerns with HR on more than one occasion, but nothing was done. She also said that she was being harassed by Mr. Widmer. Again, nothing was done. Indeed, following one more grievance, the Royal Mail even offered her over a year's pay to leave its organisation. It seems this wasn't done on a without prejudice basis, and the offer was rejected by the claimant. And then the claimant went off sick. Matters steamed ahead, and the Royal Mail started a formal termination process on the grounds of the claimant's allegedly poor performance. A manager who, crucially, knew almost nothing about the complaints or the regulatory concerns raised by the claimant was appointed to hear matters. Equally, because the claimant was ill, she was unable to participate in this process in any way. Therefore, genuinely, the manager involved did not know anything material at any stage about the claimant's complaints. She did rely, however, on evidence provided by Mr. Widmer, the manager. Mr. Widmer mentioned briefly that a concern had been raised by the claimant at one point, but he showed the disciplinary manager only the retraction email sent by the claimant. He did not show her any of the other emails in his possession before or afterwards where the claimant reiterated her concerns or similar issues were raised. Manager, inevitably you may say, dismisses the claimant on the grounds of poor performance. Not surprisingly, the claimant claimed that she was being dismissed for having raised concerns that qualified as protected disclosures. And, of course, she didn't have enough service to bring a claim for unfair dismissal, ordinary unfair dismissal. So it was all or nothing for her. The Employment Tribunal accepted that the claimant had made protected disclosures and accepted she'd been subject to detriments, including bullying and harassment by her manager, and being set up to fail. However, the tribunal said the dismissal was not automatically unfair because the disciplinary manager genuinely did not know about the complaints and so could not have dismissed her, in effect, as retaliation for having made those complaints. Obviously, that meant that the big money items, the dismissal, wasn't covered by her whistleblowing claim. Well, unsurprisingly, the claimant appealed to the EAT. Now, I suspect I know what you're thinking. Haven't we been here before in relation to direct discrimination? In the CLFIS Limited and Reynolds case, which we looked at back in 2015. There was a manager who was being accused of having directly discriminated against an individual. The manager had innocently relied on information that was provided by another employee when taking the decision to impose a particular detriment on that employee. The Court of Appeal found it was necessary to look at the thought processes of the actual decision-maker, and if they were innocent of discriminatory intent, then it wasn't appropriate to import direct discrimination findings against an individual who had innocently relied on someone else's allegedly discriminatory material. So did the EAT take the same approach here, I hear you ask? No, they did not. Under the relevant sections of the 1996 Act, a worker, which obviously includes an employee, has the right not to be subjected to, quote, any detriment by any act or any deliberate failure to act by his employer on the grounds that the worker has made a protected disclosure, unquote, stop. The worker also has the right to, quote, not be subjected to any detriment by an act or deliberate failure to act done by another worker of the worker's employer in the course of that other worker's employment, unquote. So the employer is now vicariously liable for work colleagues' actions. Where an employee is dismissed, the dismissal is, as we know, automatically unfair. Individual employees who are guilty of the bullying or harassment of the whistleblower are not personally liable for damages, although a declaration can be made against such an individual. The EAT was clear that there was no need to read across from discrimination principles into whistleblowing principles, and simply because the law was clear on discrimination on this point, didn't follow that the same approach had to be adopted in relation to the whistleblowing legislation. The EAT said the starting point was to look at what was the reason for dismissal. In employment terms, the positively ancient case of Abernethy, which goes back to 1974, says that the reason for dismissal is the set of facts known to the employer, or the maybe beliefs held by him which caused him to dismiss the employee. In an earlier case of Cooperative Limited and Baddeley, in the context of whistleblowing, the Court of Appeal had briefly considered what would happen if an innocent manager's decision had been manipulated by someone else. And the Court of Appeal had accepted in that case that potentially the motivation of the manipulator could in principle be attributed to the employer, quote, at least where he was a manager with some responsibility for the investigation, unquote, stop. Here, in this case, the EAT accepted that this approach applied to the reason for dismissal as well as the fairness of the dismissal. In other words, if the innocent manager relied on the manipulated material, easy for you to say, manipulated material, in taking the decision to dismiss, that could be a breach of the whistleblowing legislation because of the improper motivation of the manipulating manager. The EAT said, quote, I am satisfied that as a matter of law, a decision of a person made in ignorance of the true facts, whose decision is manipulated by someone in a managerial position responsible for an employee who is in possession of the true facts, can be attributed to the employer or both of them. So what does that mean, and what are the limits of this case? Well, first of all, it makes employers' lives more difficult. They are now in a situation where in some circumstances a manager who's been appointed does his or her job conscientiously and fairly can still be found to have breached the whistleblowing legislation by relying on evidence provided to that manager. This obviously extends the scope for attack for claimants on employers' decisions. However, there are limits to these findings. Both the Court of Appeal in Baddeley and the EAT in this case talk about the context being someone who is a manager of the employee, the claimant, and who was manipulating the evidence and who knew the true facts. And there are two limitations inherent in that. First, it doesn't address the situation about what happens if a fellow colleague who is not a manager sets out to manipulate the evidence. I think that would be a step beyond what's been found to be attributable to the employer so far. Similarly, the EAT said that the manipulator in this case was, quote, in possession of the true facts, unquote, stop. So someone who genuinely believes their version of events may also not be covered by the scope of this decision if they provide tainted information. In short, I think employers are going to have to step more carefully through processes where whistleblowing is alleged or is likely to be alleged. This is particularly the case where the alleged whistleblowing relates to the manager's own actions. In some ways, this particular case is a classic example of its type. The manager was asserting the employee was underperforming. The employee was asserting that the manager is picking on them for concerns that she has raised. Whereas in the past, it might have been possible to isolate the alleged whistleblowing by appointing someone to look into it who does not know anything about the alleged whistleblowing. That approach will no longer work. So employers are going to have to be extra vigilant when evaluating the evidence from a manager about underperformance where there are whistleblowing allegations against the manager in turn. So, next case. And again, I seem to pick the names on this week's episode. It's Bunaini. Bougnaoui. I won't even try and say that again, and Micropole SA. So I'm just going to call the claimant throughout this, having made even more of a mess of it than the first name. The case is a really interesting one because it takes a completely different approach to an issue which we discussed in the last episode, namely the issue of the banning of Islamic headscarves. And as I mentioned in the last podcast, the issue of dress code is very much in the public eye at the moment in the UK. And so although these cases are, quote-unquote, only opinions of the Advocate General and are taking place under the slightly different wording of the Equality Directive, they are really important. The underlying facts, by the time the case has reached the European Court, are the following. The claimant worked for Micropole in France. She was told when she was recruited that the company prohibited employees from wearing hijab, Muslim headscarf. It was said this was on the basis that the role in question was a customer-facing role. However, contrary to this, the claimant did wear a hijab when she visited a client, and the client complained. She refused to back down, the company refused to back down, and so she was dismissed. She then claimed religious discrimination, and although her claim was initially rejected by the French courts, it ultimately went all the way up to the European Court for a ruling. At this stage, we simply have the Advocate General's opinion, but it could not take a more different, and would say it takes a much more nuanced approach to the whole issue of dress codes than the previous case I mentioned, the ACBETA and G4S Solutions case. Word of caution. The Equality Directive, which is, of course, implemented in the UK in the Equality Act, sets out the same tests for direct and indirect discrimination. However, it's slightly easier to justify direct discrimination under the directive than it is under the UK Act. So, how do we get into this? Well, the Advocate General, having looked at the facts that, as I've set them out, indicated that there were really two questions. The initial question was whether dismissing someone for wearing a hijab for religious reasons was direct or indirect discrimination. Is it direct or is it indirect? And then, having decided whether it's direct or indirect, it was necessary to consider whether that act was justified applying the appropriate tests for either direct or indirect discrimination. The Advocate General considered that the ban on the wearing of the hijab at work was direct and not indirect discrimination. This is obviously crucial because flowing from that, there's much less opportunity to justify the behaviour under English law and under the Equality Directive itself. Obviously, with indirect discrimination, there is the usual ability to justify discrimination. Under English law, traditionally it's been held that enforcing a dress code equally amounts to indirect discrimination, if it's discrimination at all. It's a provision that has a neutral impact, but affects disproportionately, in this case, people who adhere to the Muslim religion. However, the Advocate General takes the view that the directive, and therefore the Equality Act, protects both the right of someone to follow a particular religion, but also the manifestation of that religion. The dividing line, in her opinion, is between manifesting a religion, i.e. wearing a headscarf to work, for example, and proselytising for a religion, which she feels has no place at work. If this is right, then the direct discrimination laws have a more extensive reach than we maybe realised, and this will have a significant knock-on effect on dress codes and other areas, I'm sure, because it's going to be much more difficult for employers to impose dress codes. It'd be much easier to find that it is discriminatory to try and curtail choices about what individuals wear to work. So, I'll give you an example. If you go all the way back to the Boychuk case in 1977, the facts of that the individual concerned, according to the case report, was a lesbian and insisted on wearing badges proclaiming her sexuality, and she was dismissed for wearing a white badge, with, written in large letters, the words, quote-unquote, lesbians ignite, unquote. Well, unless you take the view that that is proselytising, on the Advocate General's reasoning, that would now be direct discrimination, and it would be extremely difficult to see how that could be justified under the narrow test under English law for a genuine occupational requirement, which is the only circumstances in which you can justify direct as opposed to indirect discrimination. So the Advocate General then went on to say that the direct discrimination was not justified, even under the slightly looser wording in the Equality Directive. She pointed out that the derogation clause in the directive, which permitted direct discrimination to be defended, was a derogation from a general principle prohibiting discrimination and should be interpreted strictly, One of the recitals to the directive indeed says that this derogation is to be available in, quote, very limited, unquote, circumstances. And the Advocate General, in thinking about what those circumstances might be, gave an example where the wearing of a religious item of clothing might have health and safety implications, or it might prevent the employee doing work in those circumstances, or it might tripping, for example. It might justify the prohibition. But really, those were very, very limited examples. And the Advocate General noted there was no complaint about the claimant's standard of work here whilst she was wearing a hijab. And the Advocate General took the view that the French company, the employer, was trying to rely on its commercial interests to impose this ban on the manifestation of a religious belief. And if the company was permitted to ban a hijab in these circumstances, it would risk normalising, in the Advocate General's term, the particular derogation, which is a derogation the directive says should be used in very limited circumstances. She also went on to consider how the courts should approach matters if enforcement of a dress code were decided to be indirect discrimination rather than direct. Her opinion was very much in line with the approach of the tribunals and courts in England. The Advocate General indicated that religious identity is a fundamental part of a person's identity. It's not something which is politely discarded when one comes to work. To that extent, religion is no different from age or sex or race. Equally, these are aspects which are not discarded when it comes to work. And so it's no more likely to be justified if it were analysed as indirect discrimination to dismiss a woman for wearing a hijab than it would be direct. Now, all of this is going to be seen as a welcome sign by most UK employment lawyers, I suspect. The Advocate General's approach is much more focused on the evidential need for a policy prohibiting hijab wearing and the appropriate level of respect and protection for an individual, rather than giving the predominant protection to the employer's right to conduct a business as it sees fit. This approach will be much more in tune with the approach in the UK courts, but the comments about this amounting to direct discrimination will be much more problematic. But even so, it's clear that the decisions of the European Court in these two cases, due out later this year, will be of considerable importance for employers, not just in relation to dress codes, of course, but generally in relation to standards of behaviour, approach, and acceptable conduct in the workplace. So, third and final case, Fallows and Others, and News Group Newspapers Limited. At last, a name I can say. I'm going to deal with the case briefly because it represents an update on a case that I talked about in podcast number 95. And the case had a different name at that stage because it dealt with a restricted reporting order which was still operational, and the parties were identified by random letters. The claimant had started proceedings against the respondents, and there was an attempt by the employer to apply for a restricted reporting order under Rule 50 of the Employment Tribunal regulations, the employer being connected with a well-known entertainer. Rule 50 prevents or restricts public disclosure of any aspect of the proceedings if the tribunal considers it necessary in the interest of justice or to protect the human rights of any person. The restricted reporting order application was rejected, but there were temporary orders made to hold the ring, pending an appeal to the EAT. News Group newspapers came on board, became aware of the allegations and applied to intervene and be heard on the appeal at the EAT stage against the failure to grant the restricted reporting order. The employer was appealing to the EAT. Then the case settled before the EAT hearing. The issue for the EAT was whether the restricted reporting order continued to apply. There were various options. First, you could argue that the reporting order dropped away automatically once the case was settled. Alternatively, it could be argued that the order remained in place permanently, even though the case had settled, because the case was over. Or thirdly, it could be argued that the whole issue was still up for grabs because the case remained live to the extent necessary to determine what should happen to the restricted reporting order. Well, we now have the full decision with the relevant names of the parties. Since the case settled, of course, there have been no findings of fact, so I don't need to go into the details of the particular allegations. However, the key points to reiterate coming out of this case now are that the employment judge does have a discretion to consider what to do with the restricted reporting order, even though a case is subsequently settled. There was no automatic withdrawal of the restricted reporting order on the settlement of the case. In other words, the whole issue simply remained live for a tribunal judge to decide what should happen. So the EAT judge then, having come to the point that the issue remained live, considered whether there was any error of law in the balancing exercise that had been conducted by the employment judge who had originally rejected the application for the restricted reporting order. And the EAT confirmed there was no error of law, so the parties can now be named. Having dealt with this case when the case was handled under the restricted reporting order back in podcast 95, simply wanted to reiterate the warning which I gave in that episode. Clearly, where there are allegations in relation to public figures or where the allegations themselves may be very newsworthy, this case means that the ability for an employer to avoid publicity by settling the case quickly is now weakened. Once the case gets going, then if the press hear about it, this case indicates that even settlement of the case does not remove the ability for the press to get hold of the information and, if necessary, challenge the restricted reporting order. Of course, this cuts both ways. Whilst the case is underway, a claimant may find that a respondent is less likely to settle now, given that the allegations may still be aired. Conversely, it's an indication to respondents facing sensitive allegations that settlement may be seen as validating the allegations which are subsequently published, even if, in the real world, there are many different reasons for settling claims, even if they're not meritorious ones. Certainly, it will increase the pressure on both claimant and respondent in the pre-litigation negotiation stage, because once the tribunal button has been pushed and the allegations have been put into a tribunal form, it may be very difficult to put that genie back in the bottle. So, that was the case of Fallows and News Group Newspapers Limited. I think in terms of wrap-up, so obviously thank you very much indeed for listening, and stay safe until the next episode. Next episode, of course, is episode 100, and we are thinking of doing some fun stuff around that to mark the 100th episode. To be honest, I never thought I'd get to the 100th episode, so that in itself is a bit of an achievement. And we are going to run a competition, and fittingly, given that it's the festival season, and I was I've been at Latitude Festival 10 days ago, so I'll tell you a bit about that in a second. But the music competition, here's how it works. My email is nrobertson@mayorbrown.com. And what I'd like you to do, I saw this in a music magazine the other day, and I thought it was a rather good idea, so we will adopt it. Take a well-known song title, subtract only one letter from it, and with the resulting amended song title, write a one-sentence synopsis of what the song relates to. So to give you just one example, God Vibrations, which would be the Beach Boys' gospel song. You get the sort of idea. Anyway, anyone who sends in some entries, we will see if we have any of those white headphones that we have used as previous competition prizes, and we will distribute those to anyone who writes in with song titles. While stocks last, of course, I suppose I have to say. I'll work out how we announce that during episode 100. And the Latitude Festival, which was as much fun as it always is. Top tip for if you get a chance to go see Christine and the Queens. I know they're a bit of a buzz band, and it's a bit cliche to say so, but they were absolutely magnificent live. Not what I expected at all. Not necessarily even the sort of music I tend to like, but they were just brilliant. So if you get a chance, Christine and the Queens. You didn't hear it here first, but it's probably the only employment podcast that'll bang on about Christine and the Queens in July. Thanks so much for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.